Okay, good morning, everyone. My name is Christopher Bowden. I'm with the law firm of Frye and Benavides. This morning, we're presenting a webinar on knowing your legal rights during COVID-19. Our speakers this morning will be Kashmire Terry, Traci Jackson, Mischa Montgomery, and Camrii Alexcee. The topics that we're going to talk about this morning are employment rights, business disaster planning, family conflicts, tenant landlord disputes, including evictions, estate planning, and Social Security disability. Our first speaker this morning is going to be Traci Jackson.
Well, good morning, everyone, and thank you for joining us. We hope that you are able to get some valuable information out of our presentation during these dynamic times. Please know that the information that we are sharing with you does not result in an attorney-client relationship. We are giving general information. And please be aware that certain state laws may vary from the information that we're giving to you today. So, my name is Traci Jackson. I'm a 25-year employment lawyer. I have practiced this exclusively for the past 25 years, working for the National Labor Relations Board in New Orleans and engaging as a solo practitioner and an arbitrator as well as a mediator. I wanted to share with you some points regarding your employment relationship in these dynamic times and how that can be affected by COVID-19. So let's start with one of the major players in this federal statute called OSHA, Occupational Safety and Health Administration. OSHA is the law that mandates that employers, private employers, and federal employers provide a safe environment for their employees to work in. Now, of course, there's exceptions to every rule. State and local workers, municipal workers, county workers, state workers, are not covered by the federal OSHA law. However, if your state has a comparable state OSHA law, you are covered under that state law. Unfortunately, Texas does not have a comparable OSHA state law. However, don't worry, there may be some other laws and regs that will cover your safety if you are working for a municipality, a county, or the state. What are your additional rights under OSHA? OSHA requires that employers provide personal protective equipment, PPE. We've heard that acronym a lot in the last 2.5 months, right? Yes, OSHA mandates that your employer provide that protective equipment for you. And in a lot of cases, with very few exceptions, OSHA mandates that your employer pays for that equipment, okay? OSHA also states that you are to be free from retaliation if you make a complaint to that entity if your employer is not providing safety in your work environment and you feel that you have been retaliated against for complaining against that, for complaining, making a complaint in that arena. There are two types of complaints you can make. If you feel that your work environment is unsafe, you can make a complaint to OSHA saying, hey, your rules and regs are not being followed here. We need you to come out and do an inspection. Or if you have made a complaint to your employer or to OSHA regarding the safety and health and you have been retaliated against, you can file a complaint with OSHA to engage your rights as an employee. You have 30 days to file these complaints, okay? All right. I'm going to talk about next some other mechanisms that protect you if you are complaining about conditions at work, which the safety is a condition of work, right? The National Labor Relations Act that is administered by the National Labor Relations Board, okay? This act primarily governs the relationship between employers and those employees who are covered by a collective bargaining unit or a collective bargaining agreement, right? However, there is a section of this law that covers employees who are not in a union, but act as though they're in a union. And what I mean by that is if you act in concerted activity, meaning 2 or more employees, more than one, or a group of employees, go to the employer and complain, hey, we need gloves, we need goggles, we need masks, and your employer says, I'm sorry, we're not providing it, and by the way, we want you out of here for complaining, you can file a charge with the NLRB in your region. The NLRB will investigate your charge, and if they find evidence to support your claim, they will prosecute your charge for you. Unlike the EEOC, the Equal Employment Opportunity Commission, which deals with discrimination in the workplace, the EEOC attorneys don't always prosecute all cases that are found to be worthy, right? The NLRB does. You have 6 months to file your complaint. They will conduct an investigation, and if they find merit, they will file a complaint against that employer. This is a little hidden gem in the employment arena, one that people don't think about because they always associate the NLRB with unions. I know personally this works. Not only did I work there as an attorney, but I also had to file a complaint for retaliation for protected concerted activity against a former employer. They conducted the investigation, they found merit, they prosecuted the case, and I won. And it's all free of charge. These are federal agencies that you can use that are maintained by your federal tax dollars. So use them when needed. Hopefully you won't need them, but if you do, here's the information. Okay, our next subject, unemployment. So as you all know, the federal government has kicked in a lot of extra money to help bolster the funds for those who are unemployed. Hopefully, if this has affected you in that way, you have contacted your local office in your state. Here in Texas, that would be the Texas Workforce Commission, right? You can apply by phone, you can apply online to get your unemployment benefits. Also, if you are self-employed, and if you were totally self-employed in the year 2019, you are eligible for self-employment benefits. I would suggest that you get online and file your complaint. Be patient. You know, there are a lot of people who are out of work right now, but get your complaint in. The second part of that, if you are unemployed currently and you have started to get a call from your employer saying, hey, come on back to work, we're ready to start, and you wonder if you should return or can you stay home and collect your unemployment. Again, here in Texas, you will need to check with your individual state if you're not here in Texas. But here in Texas, there are some exceptions to you returning to work under these conditions. If you are 65 and over, which is the high-risk category, you do not have to return to work. If you have a household member who is in that high-risk category, you may not have to return to work. If you have been diagnosed with the COVID virus, you will not have to return to work. If you have a family member who has tested positive, you will not have to return to work. If you are currently under quarantine, you will not have to return to work. If you have children in your home and there is no school or daycare or any other alternative for your children, if you have to return to work for their safety and care, you can present that to TWC as well, or your employer, to see if you can be excused from work. My advice here is please have evidence. If any of these conditions apply to you, please have evidence to support your position so that you will not have to deal with any unnecessary issues, right? Okay. Workman's compensation. Again, this is a law that is run by individual states. Here in Texas, employers have the option to opt out of unemployment insurance, which is interesting. I think Texas is the only the only state in the country where employers have that option. I'm sure this is going to be debatable, but the question is, if you contract the virus at work, will you be eligible for workman's compensation? I would say yes, especially if you run into situations where, I've read that a restaurant here in Texas has told their employees that wearing masks does not fit with their business image. And if they have a problem with that, then they can hit the door. That in and of itself raises a whole lot of red flags. But say you agree, okay, I won't wear the mask because I want to continue to work here. You don't wear masks, you don't, do any of those things to help protect yourself via your employer. Heaven forbid you contract the virus. I would say, if it happened to me, I would apply for workman's compensation, and I would also make sure that I have evidence that I contracted the virus at work. You've heard of some of these businesses who are closing immediately once they find out one of their employees has contracted the virus. So people talk, especially if you have an employer who is not abiding by OSHA regulations or state or other federal regulations that may govern their entities. Make note of those things, ask questions and keep documents, right? But let your workman's comp organization tell you, no, this is not covered. But if I contracted the virus and I was pretty sure that I contracted that virus at work, I would apply for workman's comp, okay? And also in the state of Texas, where an employer can opt out, if they are not under workman's comp insurance, then you have a viable allegation against them for negligence under regular tort law, personal tort laws, right? Especially if they have not been complying with rules and regs regarding protecting their employees from this virus. All right, layoffs. There's one federal statute that governs layoffs in this country, and there may be other state statutes that govern them as well. Texas does not have a state statute that governs layoffs. The federal statute is called the WARN Act, right? So that basically says if an employer who has over 100 employees and they are going to engage in a mass layoff, they have to give you fair warning. They have to give you that warning within a particular amount of days and let you know, what's going on. If employers fail to do that, they face some stiff penalties and fines, okay? Along with that, severance packages. Some people who have been laid off in Texas, Houston in particular, is experiencing a lot of layoffs in relation to the oil industry and all of the organizations, companies that support that industry. Some companies may have a policy where severance packages are given. Collective bargaining agreements may contain language dealing with severance packages. Employers may offer severance packages as a way of a compromise. If there's some things that have been brewing with your employment prior to the pandemic, say you've made some claims of whatever with your HR people, or maybe you have an outstanding charge with the EEOC, or some things are kind of going on beneath the surface. Your employer may offer you a severance package as a way to get from underneath a finding of liability. So basically, a severance package will give you a certain amount of money for a certain amount of time in exchange for you promising that you will not sue them for any employment-related law violation or pretty much anything else. Some of these packages may contain non-compete agreements, along with some other things. So there are certain guidelines these packages must meet. I would advise, if you are faced with this, that you do consult an attorney to make sure all of your rights are protected and that there may not be any ill motive behind your layoff, discriminatory motive. Okay, disability. So say before the pandemic, you were an employee who was being accommodated for a particular disability. And the pandemic hits, and now you're being called back to work, or if you've been working from home, you're bringing you back in, or whatever the case may be, you're coming back. Will that accommodation still be in place? The short general answer is yes. Your employer must still accommodate that disability. However, if the employer can show that your accommodation causes an undue burden, that may get them out of that, right? Employers cannot inquire if you have an autoimmune disorder that would make you more vulnerable to the virus before returning to work. They cannot ask you those questions. They can ask you questions that are not related to your disability, right? They can require new employees to take medical exams. They can take your temperature. They can require you to wear masks and other personal protective wear. They can encourage you to work from home. They can ask why you have been absent, right? Employers cannot rescind a job offer if a medical exam shows that your immune system is compromised. They can't come back and say, oh no, well, you may catch the virus because you have some issues, so we're going to take back our offer. They cannot do that. They cannot force employees to take a vaccine, okay? So just some things to be aware of. I personally think big employers will continue to allow their employees to work from home because it kind of relieves them of this burden to follow all of these OSHA and CDC recommendations. It's much easier if people can work from home. Last but not least, I just have some miscellaneous tips. Communicate with your employer in writing. You have emails, you have text messages, you have social media, you have all kinds of ways to communicate with your employer in writing now. Ask questions. Remember, everybody is learning as they go with this. Nobody has all the answers. Everybody is consulting everyone else who they think has more information, lawyers, government agencies. Ask questions and ask them in writing. Read your employer handbooks. Read your collective bargaining agreements, right? Keep documentation. And one other tip, if your state, as they do here in Texas, allows one party to a conversation to consent to that conversation being recorded, and that person can be you, if you are in the conversation and you want to record conversations with your employers. especially if it's some heated stuff going on. When I worked for the NLRB, union organizers who would go into these employers' venues and go right up to managers and supervisors and tell them, look, we are here to organize your employees. We want them to be in our union. And almost always the employer would say something unlawful like, we will never have a union here. Those organizers had recorders. They recorded those conversations, and they would come right down to the NLRB, file a charge, hand over those tapes, and we would find cause and file complaints on behalf of those unions. So be smart. You have to be strategic. I pray and hope that none of you have to deal with any of these issues in your work environment. But if you do, here are a few tips. And now, if anybody has chatted any questions, Christopher, in the chat room, I'll be happy to try to answer a couple. No questions. All right. Well, I hope you have found this information to be helpful. And thank you very much for your time.
All right. And to our next speaker. Kashmire, you need to unmute your microphone.
Oops, sorry, forgot I was muted. Good morning, everyone. So my name is Kashmire Terry. I practice business and entertainment law here at the firm. Today, particularly, we will be discussing business disaster planning. So my job at the firm, I range from handling mergers and acquisitions to small business planning to business and governance and handling contracts. So with this time in COVID, there's three things that we really need to address as we are trying to move forward, right? We know COVID, a lot of businesses, small businesses are taking a hit. We see businesses, huge ones, even like J. Crew, JCPenney's, just filing for bankruptcy, right? So with this, we know the big businesses are taking a hit. Our small ones are really going through it, right? So the government released the CARES Act. And with this, we know the CARES Act brought the economic disaster loan and the PPP loan. Many businesses went for the PPP loan, of course, because it allowed for maximum loan forgiveness, as well as being able to keep their payroll, being able to help with their employers. This was great. Well, now that we're opening up, and many states are opening and the economy is starting to come back, we're looking at the time frame where the PPP loan is starting to become due. So as we are entering this new change and looking for the future, these are a few things that you need to look for. So one, as your PPP loan is becoming due, we know that 75% of what you received was to be allocated for salary, tips, wages, leaves of absence for your employers. Also within this PPP loan, remember that if you are a solo practitioner or if you were a self-employed individual, you are also eligible. Well, the remaining 25%, be sure that you are using the 25% to utilities, debts, and existence, all that occurred before February 15th of 2020. That is in the CARES Act. Anything that happened after February 15th may affect your maximum forgiveness. Okay, because the ideal is to be able to keep the business viable. They want to make sure that you were taken care of before that date. So, for example, let's say you had a loan, or I'm sorry, a mortgage that was due, right? The mortgage was already in existence before February 2020. You're looking more so and being able to be maximum forgive for using that 25% of the loan toward the payment of that, right? Well, if your rent or your mortgage occurred after February 15th and you signed that contract, then that's when you may not be able to receive full forgiveness of that 25% that you took because you're after the February 15th date, okay? Also, it is very important, many times the lenders gave a general repayment frame of 8 weeks, right? So from the time that you first got your disbursement of money, you have 8 weeks to be able to to use it, to use the 75% for payroll, the 25% for other needs, right? Well, in those 8 weeks, after that is when we start getting into time to repay, time to calculate and handle your documentation, right? So while you're looking at that, make sure that you are having the documentation into your who received payments for your payroll, what utilities were paid, what mortgages were paid. Make sure you have your receipts, and also make sure you are not firing people during the time that you've had this PPP loan. That's going to affect your forgiveness, okay? You firing people, that's the whole goal of why the Congress, not the Congress, but Congress released the CARES Act and for the PPP to keep people from having to go to the unemployment line, okay? So keep the head count of employees the same. You can give them bonuses, but you cannot decrease their pay. If they're making less than $100,000, you cannot decrease their pay more than 25% once you've received the PPP loan, okay? That's something to remember. Now, let's say, just in case if somebody had to be let go and you're worried about those funds. Well, what you can do to try to recover that percentage is give bonuses for the remainder of that amount that that individual that was let go would have been receiving, if that makes sense. Now, we're calculating this to make sure that with the PPP loan, you have 100% forgiveness, but you have to be able to prove and attain that. That's not just given. Otherwise, you have to pay back the portion in which you used, right? In comparison, we know the economic disaster loan, that loan is not necessarily forgiveness. That's a 30-year term rate, okay? Moving forward, also making sure that some of the documents you need to have in order to have your loan forgiveness, verify the number of employees, their pay rates, have your IRS payroll tax filings from 2019 as well, and your state income, payroll for unemployment and insurance filings. Also documents for mortgage, leases, utilities, and also you're going to need to make sure you have a certified representative that can pretty much verify to the government that these are common business records and that these are legit coming from you. All right. So a formula that has been going around and that would be very beneficial for you to know. And kind of see, okay, are you going to have maximum forgiveness with the loan, or are you going to have to pay back a few of those dollars? Where are you going to fall? Here's the formula, okay? Now, first you'll need to determine, one, the average number of full-time employees you had from the time you've received your initial loan funding, okay? Two, the average number of full-time employees you had from February 15th, 2019 to June 30th, 2019. Those are two separate numbers, okay? Three, you'll have to determine the average number of full-time employees you've had from January 1st, 2020 to February 29th, 2020, okay? So you're going to take, in order to calculate where your loan forgiveness is going to fall, you're going to take the calculated step in step one, the average number of full-time employees you had from the time you received your initial loan funding, and divide it by the number you calculated in step two. Okay, we'll call this A. Keep it simple. Do this again, but now you're going to divide step one by the number you calculated in step three. Okay, so let me kind of remind. You're going to take step one, divide it by step two, got your number. Then you'll take step one and divide it by step three, the average number of full-time employees you've had from January 1st, 2020 to February 29th, 2020. Okay, and we're going to call that number, or that number, letter B. Okay, so you have two figures, A and B. Okay, now to determine if you've met the requirement, you're going to use the larger of A or B. If your number is greater than or equal to 1, then you successfully met this requirement. You will more than likely receive full PPP loan forgiveness. We like that, right? If it is less than 1, right, you did not meet the requirement to receive 100% forgiveness, okay? Now, you also want to make sure that you're maintaining salaries. Increases are fine. And I've already kind of hit that. So in looking at repaying, okay, remember that in repaying, if let's say, okay, you didn't reach the maximum loan forgiveness. Well, thank goodness in the PPP loan, your outstanding balance, whatever that balance is, you will only be accruing interest at 1% for 2 years. After that, you'll also have a 6-month payment deferral. You don't really find loan terms like that. So that is really good. You don't see 1% for 2 years, right? So hopefully as we're opening up, that'll also give you a chance to kind of pay it back as much as possible. But that's if you fall under the loan threshold, okay? So that's why it's so important that you're making sure you're retaining your employees, and that you're spending the money that was given to you in the right ways. Not only keeping the documentation, but also making sure that 75% that you've received goes to payroll and the remaining 25 goes to utilities. The idea is to keep you steady, to keep you surviving, right? If we can get you to survive and break even, we're good. We'll worry about tomorrow, okay? So that's what the PPP loan was, to make sure you're surviving, businesses are still working, and keeping people from the unemployment line, all right? So that's the forgiveness formula. And yeah, just please make sure that as we are nearing the term or the end of our 8 weeks, make sure that you are keeping your documentation and you are running the numbers every now and then, just to make sure you are under that threshold. The second thing, just in recovery for businesses, how do we plan for the future? Okay, so I have some tips, and just reorganizing. A lot of times, a lot of businesses weren't able to go for the PPP loan immediately because they didn't have their documentation in order. They didn't have their lists of payroll expenditures. They didn't have their IRS. It was a mess, right? It was the documentation that prevented them from being able to apply at first. So here's some things I want us to keep in mind, that now there's no longer business as usual, right? COVID has kind of changed things, the way that we operate with each other, and also the way that we are now doing business. And so I'm sharing with my clients to make sure, look, we're not going to rely on the building. We're not going to rely on a building to keep business going. This train stops for nobody, right? So business has to continue, whether we're in the building or we're at home, or, I mean, if another Harvey, God forbid, but if another Harvey comes, business has to move forward, right? Do not let, our goal is to have systems in place to not let a disaster take you off your game again, right? So it has definitely taught us. So planning for the future, here are a few things that businesses need to begin to do as we are opening up. First thing, create a continuity plan. These are the necessary functions of the business. What functions of the business, if we were to get to the bare minimum, what needs to happen? What do we need to keep? Areas, whether we're in a goods type of business or a service, what do we need to have in order to survive, okay? Also, identify your key players, your staff, your equipment to keep going, right? We might need at least 3 computers instead of all 30 that we have, right? What are those things that keep creating a continuity plan? Also, identify the bare minimum. If you were to cut off some things that the business likes but don't necessarily need, what is the bare minimum that you need on the administrative side for your business? This will help you identify your expenditures. How much do you need to bring in to survive, right? And this will also help you identify, okay, and instead of firing people, let's just cut down some of the services, we might not need for lawyers LexisNexis right now, or we might not need, I don't know, what's something else that we need? Our online dictionary subscription, right? There's some things that if you're doing a continuity plan, your continuity plan is AKA your disaster plan, right? If we were to get into a situation, what do we need to survive? Also, outside of just that, I also suggest having an organized accounting system. Preferably do a reconciliation every quarter, okay? So that way you are constantly touching your books You know what is coming in, what is coming out, and then your future self will thank you, because when it comes time for taxes, the IRS, you already have it in order. It's all about just inputting and moving forward, right? So always keeping an accounting, quarterly reconciliation. Also, having access to your important documents both online and remotely, okay? So if the internet were to crash, don't worry, you have a hard copy. If your building were to flood, or if something were to happen where you can't get in the building, you have it electronically. There will always be some way and form to access those important governing documents, your past IRS taxes, your vendors list, your payroll. Those are those documents of that nature. Identifying your key players, we went over that, but more so going in a little bit more in depth. So knowing your business, the key players who would be the person, if say, let's say we had a hurricane, who would be the closest person you could send to check on the building or to board up the building, right? Who would be the person that you can have on the phones that would be able to access and still be able to manage your clientele, right? Who would be the person that would still be able to handle your ordering and your inventory of the things that you need? And also, who would be the person to still manage your finances, right? So whether we're all together in a building or not, these key players would still be adding to the business and still working. Also, I also suggest having a client database, not just these are the people we work with, but having open communication. Don't just rely on the news to tell others about your business, right? So whether that's a newsletter saying where you can tell your clients, hey, we're closed for this amount of time, but we're coming back here, or here we have a sale, right? Have open communication, whether it's a lot of times right now with technology, there's this text message service that people can subscribe to keep in contact with businesses, and businesses can give them discounts during regular times. Businesses can say, hey, we're only open for emergencies, or hey, we're closed temporarily. So don't rely on the news or the newspapers. Have a direct way to communicate with your clients. Also, have online ordering systems, or at least requesting service systems. So for like our office, for example, we have a system where clients can still contact us, not just by phone, but can ask questions, they can upload documents. They don't have to necessarily come in the office. So that helps us also in making sure that we're staying safe. So online ordering systems, if you're a food service, or requesting systems for service. Also, create your own village. This is really beneficial. Creating your own village means you can have partners, whether you're in a similar industry or complementary industries, where we can rely on each other. So if you're doing an event, hey, I have a partner, let's tag team as we're opening up, right? That means we're, one, get to split cost, and two, I'm being able to tap into your clientele and you're tapping into mine. Greater village, right? We can rely on each other as we're building up. Also, have an idea of your crisis threshold. So there should be some key players in your business, top people, not just the owner, but maybe a manager, an officer that is connected really with the people that are working for you. To all on this board, let's just call it an executive board, that will say, okay, we're in a crisis as a business. This is time. It's time to go to our continuity plan, right? That decision shouldn't just be on one person. One that's not only a heavyweight, but other people may have different perspectives. So you want to have a kind of like a crisis board and know that threshold of when is it time for us to implement our continuity plan, okay? Also, in your contracts as a business, as you're opening up moving forward, please make sure that you have force majeure clauses saying if there is a nature or act of God, that the service that you are either submitting to or receiving can be halted, or there can be an adjustment in the price. You don't want to be on the hook for something that, I mean, you haven't received, but the price doesn't reflect that, right? So force majeure clauses are highly, in your contracts, highly advised. Insurances, as we're opening, make sure you're looking into flood coverage, physical loss, And business interruption, that's a big one. If there is a business interruption, COVID was a business interruption. It wasn't necessarily a physical loss of damage happening to your office, but if the loss in income, there's insurances to cover for that. So I do suggest looking into those. Savings for business, also creating a reserve fund. There should be every business, I mean, if we were in an ideal world, it sounds easier than it is, I understand, but every business should have a reserve fund, meaning enough to at least cover 2 to 3 months, just like you would do with your personal finances, 2 to 3 months of basic operating costs. That's why you have to identify what, if we were to cut down some of the luxuries, what do we need to survive as a business, right? So having a reserve fund. And also revisiting the structuring of your company. Now is a great time. Look at the accounting and the finances, the services, the essential services, maybe having division team leads so we're functioning better as a unit. Document storage, and then also looking at your company communication source, externally and internally. Next, the third thing I want to bring to your attention as we are just entering new post-COVID, succession planning. I know that this COVID hit a lot of people in our personal lives, not just businesses, right? But what happens if the owner is no longer able to, they're sick, they're no longer able to run everybody, right? Not only do you need to have your backup person, the person to step into your shoes, but then also it still needs to run smoothly. So this is what we go into succession planning of grooming your successor early, right? Whether that is just a manager that will step into your place if something were to happen, or whether that it's a family-owned business and it's your child or your cousin or your aunt. But start grooming them so they know the ins and outs of the business. There are plenty of people right now who have businesses that didn't think about this, and now the money for their family is stopped, right? The income, everything is stopped because they've either passed or they're sick. Well, that affects moving forward and trying to get out of this. So groom your successor. Buy life and disability insurance for your partners. So if you have a partnership, right, if there's more than one owner, look into having life insurance on each other, where the business, you can either have the business be the beneficiary, or you can have the other partners be the beneficiary on that loan. Also, a highly suggested insurance would be also key person insurance. So if that key person is where the business runs around, if that individual were to be incapacitated or were to pass, then that's when the disability, the insurance would be being paid out. Have power of attorneys. Power of attorneys, whether that's statutory or durable. Also have an exit succession plan or a death and accident plan. This will allow if somebody was removing or retiring from the business, that's when that would kick in, or if something unexpected would occur, then that would be their death and accident plan. Training programs and having employee handbooks. These are often overlooked, but these are the key things that keeps the business running, that people know whether your secretary is there or not. They can look and reference the employee manual to see how the business runs. They can use the training programs to see, oh, this is their job, right? So you can have someone temporarily take over. Also, partnership agreements, outlining in your partnership agreements, you need to outline what would be, as a partnership, what is the limit for your incapacity? What would you do to determine being incapacity? Do you want it to be only through the courts? Do you want there to be a written notice from the person's doctor? How would that work within the partnership? And also looking at buyout agreements. So yes, these are just a few tips that I want to put in front of you as we are opening up and to be able to bounce back from COVID. We're operating as a village now with COVID-19. And I think if we rely on each other, we can get back. I don't think we'll ever be as business as usual, but I definitely think we could be better than what business used to be. We just have to do a few adjustments. So these are my tips, and thank you so much for listening.
Thank you, Kashmire. Our next attorney will be Mischa Montgomery.
Good morning, everyone. It's still morning. My name is Mischa Montgomery, and I primarily focus on family law. I have been in the legal field for almost 15 years, initially as a paralegal and then now as an attorney. And family law was and is basically what I've done. So I pretty much done everything that you can do under this umbrella, and there's a lot of things that I'm going to unpack during this, and so let's get started. So I want to preface all this with saying that it's really important during this time to understand that I know we're all quarantined. We're supposed to be staying at home and being safe. But when it comes to family law, it's really important, especially if you have children, to really come together and try to co-parent. Try to make this easier for your children and for yourselves. Because this is not an easy time for anybody. And so courthouses are still open. You can still file for divorce. You can still file modifications to your court orders. You can still enforce your court orders. You can still file protective orders if you are in a domestic violence situation. And so I'm going to address each one of these points with you. Starting with divorces. So the state, how it is right now, we don't know whether or not or when we will be able to start going and doing trials right now. So that in the foreseeable future, right, there's courts that are trying to implement how to go about, getting back into doing trials. But as of right now, trials, people have tried to do trials via Zoom. It's not really working. It's very difficult and it's cumbersome. So right now and probably within the next 6 months, it's not going to be foreseeable to do trials. So with that being said, there's many different alternatives to a trial, right? Such as mediation. So this is where, a third party neutral comes in and, says, let's come to an agreement. And mediations are at an all-time high right now. I actually tried to schedule a mediation for next month, and I'm being pushed to the end of July. So it's really crazy right now with mediation, but it's probably the best right now so that the parties, are able to get some type of resolution, right? Divorces are hard enough, without a pandemic. So going through a pandemic and going through a divorce is probably way more stressful, 10 times more stressful than a normal divorce proceeding would be. So what that being said, it's good. It would be good for the parties to come together and come to a mutual understanding. What are your goals in seeking divorce? What are your goals with your children? How do you guys want to divide assets? You may not get everything you're asking for. You may not, and you shouldn't go in expecting to get everything that you're asking for, you're wanting. And so mediations right now are the basic means for settling cases, settling divorces, and coming to some type of resolution where both parties can come to an agreement and, basically, get out of their marriage. I always tell people that divorce is the death of a marriage. So, it's never a great time for anybody. But if we can make it easier, especially during the pandemic, then, it'd be best for all parties to cooperate with each other. Another way, and in lieu of trials not being conducted probably in the foreseeable future, there's also a concept called collaborative divorces. And this is a way to where we do not get the courts involved at all, right? The parties have, come together with a common goal, common understanding, and have an agreement to where it's, feasible and workable for both parties, and then come to a resolution, right? And then this is not just for divorces, but it could be for any modifications or things like that, and I will address those in a minute. But a collaborative divorce is an easier way, as long as the parties agree, that and without court involvement, that the parties can come together and get a resolution for what they're seeking. I know right now it's this is very contentious. Everything's very contentious right now, and using mechanisms like mediation and collaborative agreements is the best way, seeming though courts are still acting remotely. Even though you're able to file things on the internet, and you're able to file things with the clerk's office. We're not always able to go into the courthouse right now, and a lot of judges are really handing out a lot of rules about what they think when we do go back to the courthouse, as far as what wearing masks and protecting ourselves and things like that. So with that being said, mediation and collaborative agreements are going to be the best way to try to resolve these situations without getting court involvement. And it's highly recommended right now until we are able to get in front of a judge or get back into the courtroom and resolve issues that way. And so I'm going to move on to modifications and enforcements. Sometimes these go hand in hand, and especially during the pandemic. And I've been speaking with a lot of my family law colleagues. These have been really, really. It's been voluminous. Let's just say that it's been overwhelming, right? As far as modifications, you can do a modification for custody, and you can do a modification for child support. I know a lot of people have been laid off, and a lot of people are not working right now. You can do a modification for child support, and and you can do that as long as the current payment in child support that you pay right now is different by either 20% or $100. So if you're gone from an income of $3,000 a month and you're no longer working, or you haven't been working for the past couple of months, you can go to the court and file for a modification. And they have been granting these modifications based upon people not working right now. And we know that we don't know when people are able to fully go back to work. Now, with that being said, if you are collecting unemployment, that's still considered income. So if you do a modification, be cognizant of whether that the unemployment is more or less than what you actually would be getting if you were getting when you were a paid employee. So that's gonna, even though it's still considered income, that's gonna significantly affect whether or not you are going to be able to do a modification, right? Or whether a modification is even necessary. And so be cognizant when you're doing modification of child support to make sure that there really is a need for one, especially for the child support aspect. Now, for the child custody aspect, the Texas Supreme Court has issued several different emergency orders through this. I think we're on number 17. It's been really insane when it comes to family law right now. And people are asking, parents, the custodial parents have been withholding the children from the non-custodial parent. Let me first and foremost say if you can't do that while you're not in a pandemic, and you can't do it during a pandemic, right? That person still has rights. The non-custodial parent still has rights to possession and access of the child, even though we are in the middle of a pandemic. And I'm glad the Supreme Court has issued this over and over and over again and affirmed this. And so that was a really big issue when we initially had these stay-at-home orders, and we were basically inside the house for a good month and a half, and nobody could really go anywhere. That was a huge issue. And a lot of people, just the custodial parent was like, well, I don't want my child exposed to the COVID. I don't know what this person or she, the non-custodial parent has going on in their household. I don't know if they got anybody sick. That's not an excuse. The Supreme Court has said that that's not an excuse for you to deny possession and access, right? So another reason why I say modifications and enforcements go hand in hand is this is the reason why, right? Because you might need to do a modification of custody or maybe a little side agreement to, try to figure out a makeshift possession schedule based upon being in a pandemic and being quarantined. But you can also do an enforcement for a denial of possession and access if you are a non-custodial parent. So with that being said, you got the responsibility of so with that being said, it's best that the parents at this time come together and say, look, what's best for our children, versus saying things like, I don't want him to have access, or I don't want her to have access. I don't know what's going on over there. I don't want my child to get sick. I don't know if they're protecting themselves. You can't worry about that other person's household. And that's not your job. Your job is still to follow your orders. And if your says that your child the non-custodial parent has a standard possession order, which is the first, third, and fifth weekend, and 2 hours on Thursday, generally, then you are to make sure that the non-custodial parent has that visitation. You cannot withhold the child. If the child doesn't want to go, the child still has to go. So, I mean, it's I know people are really concerned about that type of stuff, but when it comes to these orders, you can't violate them, because they can, the non-custodial parent can easily say, well, I'm going to go file enforcement because you failed to let me see my child. And you will be held in contempt. You could be held in contempt. You can go to jail. You can get a money judgment against you if you are found to be in violation of a court order. So that's why these things are so important. It's so important to make sure that you're following your orders, and it's important to make sure that the non-custodial parent does get time with the child. What if your child is before I go there, the exchange of the child, right? So you can still read your order. If your order says it's a drop-off pickup at some one of the houses of either parent, go by the order, right? If it's at a police station, go by the order. Whatever your order says as far as the exchange of the children, go by the order, right? If your child is out of state, so maybe the non-custodial parent doesn't live here, or maybe that they're working somewhere else, or they live somewhere else, you you can still exercise your visitation, right? Now, I know a lot of states, did a ban on certain states, whether they can come in and out. that's not going to supersede any emergency order that the Texas Supreme Court has issued. So with that being said, if your child is supposed to catch a flight to come see you, that's still something that is, viable. And if there is a denial, you can do an enforcement. You could also do, means of technology, right? There's FaceTime, there's Zoom, there's Skype, there's different ways to be able to talk and communicate. And I know that's not the greatest substitute of physical possession, but it's still a means. It's still a way for you to be able to see your child, to talk to your child, to communicate with your child, to see, physically see your child, right? So use that opportunity to, use the technology that you have to, be able to talk to and see your child. These are not, uncharted territories. So we have to adjust in order to conform with what's going on. And so don't discount, the use of technology as a means of visitation. So I would like to make a final point and this one is kind of a sensitive topic, but it is a very necessary topic that we have to discuss, we have to address. And this is domestic violence. And I know you have seen that there has been a rise of domestic violence in the media, and people are quarantined in their homes with an abuser. Let me just say that you're not just because we all have a stay-at-home, stay safe, quarantine order doesn't mean you have to stay in an abusive relationship. Make a plan. If you know that this person is abusive, you know that you are subject to abuse, that your children may be subject to abuse, create a plan, right? Moving family. There's still shelters that you can, go see, go to and live at for a while if it's necessary. Live with friends. There's plenty of places that you can go. But with that being said, you can also file a protective order. And a protective order also has this lovely little thing called a kick-out portion. And that kick-out portion basically tells the abuser, hey, you get to go. And while I get to stay here because you've been abusing me or you've been abusing my children. So a protective order is not just for you. It is also for the children as well. So that's to make sure that everybody is safe, right? So you can have a protective order with a kick-out order. Especially if you don't have a place to go, the kick-out order is very beneficial for that. So a protective order can last up to 2 years, and you can renew a protective order, if it's necessary. For a protective order, there must be a finding of family violence, right? There has to be some sense of family violence. It's not, it could be emotional, but it could also be physical. It could be both. So you're not, I know we've seen people who have been physically abused, physically beaten and everything, but it's also emotional. So a protective, if you're living in a situation with someone who's emotionally abusive, mentally abusive, physically abusive, you can still go, the courts are open. So none of the things that I have discussed with you today are on hold. Family law lawyers have been working overtime nonstop because people are just not following orders. People are in abusive relationships. People are not happy with each other. So you can still go through every single one of these things that I discussed today, and if it's if it's a necessary for your situation, definitely assess your situation and figure out whether or not you need any of these things. I pray everybody stays safe, and especially if it is a family situation. I cannot tell you how many people have come to me and just tried to really, seek advice about certain things in family matters. This has been very emotionally exhausting time for me. So so I know what it is for you guys. So I hope this was all informative for you and that you received good information. Do know, and I'm just going to leave you with this, do know that you have rights, that your rights are not on hold. They are not at a standstill during this time, and they would continue until, end of time. So if you decide that you need to take one of these routes, please do so, and please contact our office and we will get you taken care of. Thank you for joining us today.
Thank you, Mischa. We've got a couple of questions.
Okay.
One of the ones in the question area is that let me see, sharing and learning today. I look forward to anyone webinars. We are going to have some more webinars coming up in the next several weeks, and we're going to try to drill down on some of the specific issues that you guys are answering or asking questions about. Let's see, we also have some chats questions. Let's see what we got in the chat room. Let's go back to top. Looks like we've got some of these chats have been answered also already. Yes, to Tanya, yes, the webinar is being recorded and it will be available on the website. We're also going to upload it to YouTube so that for the people who want to access it through their YouTube work. Let's see. It looks like the rest of the questions have already been answered. So we'll go on to our last and final attorney. And don't forget to unmute your microphone. And it's Camrii Alexcee.
Good morning or afternoon, guys. My name is Camrii Alexcee. I have been an attorney for about a year now. I have done various things from work to in-house counsel, litigation, transactional work, real estate, the whole nine. I kind of got into landlord-tenant before I was ever a lawyer. Just kind of dealing with my own issues and having to go and look at a lease and, figure out how can I make, this situation work for me, or how can I improve my situation? Because a lot of times when you're dealing with landlord tenant, things move a bit differently if you know your rights and you know how to enforce the rights. And there's so many things I've seen that have happened with tenants and landlord that's like, this is insane, but the tenants don't know. They don't have an idea of how to get out of the situation. They don't know how to get this repaired. They don't know, basically how to assert their rights. And, that sparked the passion in me because it's always, normally a lot of times lower income people who are having these troubles. So I started out with that before I ever even, graduated or started law school, dealing with some things personally myself. So once I've started, I've continued to do landlord tenant on the side, especially stuff for, family members or friends, or, even just something maybe I've seen on Facebook because I want to help, in these situations. So basically, mostly what I'm going to focus on today are evictions in the pandemic. As you guys know, Governor Abbott, he, passed an emergency order, the 12th emergency order, which told any hearings, trials, proceedings dealing with an action to recover possession, so basically an eviction. Those were told until May 18th, 2020. And, it's now May 29th, so we've kind of moved past that. And the most recent emergency order was the 15th. And so what the new order says is that a writ of possession may issue, but posting the written warning required by Chapter 24 of the Texas Property Code and executing the writ may not occur until after May 25th. So again, it's May 29th that we've moved, past that. So you can now, issue the writ, you can now execute the writ, you can now post the warnings. And then also the deadlines required by the Texas Property Code were told that were suspended while, the order was in effect. Like I said, now it's, 4 days past that time. And now new filings may be accepted, but again, time periods and deadlines have been suspended again until May 18th. So we're past that. Those are our protection, tenants' protections. And now sitting at May 29th, those protections they're kind of gone for most. And that is dangerous. People still don't have jobs. Unemployment is crazy. And I am generally concerned about the amount of people who will be out on the street. You don't have a job, so you can't get another apartment because you have no proof of income. You can't afford.
Did it freeze?
Folks, Camrii has frozen up there for a second. We'll give her a moment to get reconnected and see what we can do. We'd like to say at this time while we're waiting on her that she looks like she may be trying to reboot. While we're waiting on her, just remember that you can contact the law firm if you have any questions after this, that you think of after this. You can send it to one simple email and we'll disperse it to the appropriate attorney. It's info, I-N-F-O, at liberatinklaw.com. Info at liberatinklaw.com. And we'll forward that email on to the appropriate attorney. You can also call us on the phone at 713-227-1717. 713-227-1717. And we'll give her just another moment. Let's see if we've got any other questions.
She's back.
She's back. Are you back, Camrii?
I don't understand. I've been sitting here this whole time, no issues. Now when I talk, it doesn't work. Okay. So I do have my notes. Okay. So now a lot of those protections, they're gone. It's the 29th. So beginning May 19th, eviction proceedings may resume. It's pretty much, as usual. Beginning on the, God, please don't lose again. Beginning on the 26th, writs may be posted and also executed. So starting now on their evictions, unless you're maybe in a city with local orders such as Dallas, Austin, San Marcos, they're still kind of tolling some of their evictions and encouraging, local, courts to not go forward with evictions. Unfortunately, Houston does not have protections. At this time, at least half of the Justice of the Peace courts in Houston have evictions proceedings scheduled the week of June. So they are moving fast, and there's not much you could do about it except for maybe it's kind of on landlords if they want to continue to extend protections to tenants, and a lot of landlords won't. So I think there will be a lot of evictions going on, a lot of people without homes, and then but there are additional protections under the CARES Act. So under the CARES Act, if you have renters at homes covered by federally backed mortgages, they still have those same evictions and those proceedings and writs being told until August the 23rd. So there are very few, lucky people who, will be able to continue to receive these protections. And, even August 23rd, I don't think that's because if you haven't been working since maybe March and you're 3 months behind on your rent, you go 3 months, 4 months, 5 months, and now here's August 23rd. So now we need all your money by August 23rd. You still don't have a job. The federal, that extra $600 the federal government's been given, I believe that stops at the end of July. So people are going to be in very, very sticky situations. There's already a homelessness issue in Houston, and it's about to be exacerbated by what was to help people. And I don't know. I think it's kind of mind blowing to just throw people back in, though we don't have jobs, to say, now your rent is due. Hey, these protections are gone. I don't think there's been enough time given to people to be able to prepare for something like this. And also landlords will suffer because you evict someone, you're going to need someone to come back in. And I think, those rates of people renting are going down. But for eviction proceedings filed from March through July 25th, a sworn petition containing a description of the facts and ground must state premises are not subject to moratorium on evictions imposed by the CARES Act. So basically, those homes that are backed by federally backed mortgage, the landlord has to put into their pleadings that they're not covered under this, because of course tenants don't know. Tenants wouldn't even know where to start. I do think that's I think that's important. They're required to do that. But this is all from the most recent 15th emergency order, and this order is effective, I believe, a few days ago, and it expires July 25th. So basically, we were given, tenants were given protections up until between March and up until just a few days ago. And for the most part, those protections have been lifted unless you are renting in a home covered by a federally backed mortgage. And the State Bar of Texas, they have sent out information in regard to pro bono opportunities, because there are going to be a lot of people who do not have the money to not only pay rent, but to also defend themselves in a hearing or proceeding, or, try to get more time or some kind of deal, with the judge. So if you, are an attorney and you are interested and you do have that time, you can go to the State Bar web, and there's a, easy link that'll show you how you can sign up to help these people who are also, still suffering in the pandemic, who, may not have anywhere else to live, and they get this eviction on their record, they won't have anywhere else to live. The amount of places in Houston that allow for, broken evictions when you're renting new is, almost nil. And if they are there, they can sometimes be unsafe. So I think we have a duty, and, especially if we have the time and the ability to help these people, to volunteer. I volunteer all the time. I do landlord tenant stuff from demand letters all the time for free. It doesn't take me that long. I'm passionate about it. I don't like seeing people, eroded by people who just want to take advantage of you. So if you have that time, please, go onto the State Bar of Texas website and, volunteer to help out with some of these evictions. Represent landlords. That's on, that's up to you as well, but that is available. And my internet connection is trying to be unstable again. If you have more questions, or if you want to kind of reach out and, you have any clients who are dealing with these issues, I'm extremely willing to take a look at it. You can email Camrii, Camrii .Alexcee, ALEXCE.com, and I'm always willing to talk about landlord tenant stuff. And I hope you guys learned something from this. And if you have any questions, throw them in the chat. I'm gonna look really quick. But yeah, that's all I have for you guys. And yeah,
All
like I
right.
said, in the chat.
All right. Thank you very much. Let me see if we have any more questions. We've answered those. Who would like to answer some of these questions about the business and wearing masks? Would that be Kashmire? Would you like to answer that? Kashmire, would you want to unmute your microphone?
I keep forgetting to unmute. Sorry.
That's okay.
Well, if the business is asking, it is they're well within their rights. It's a matter of public safety and health. So asking you to wear a mask, refusing service, a business has a right to refuse service to anyone. So as a matter of public health, they're perfectly, especially following the CDC guidelines.
All right. How about approach with a forced vaccination? Is my refusal rights besides saying no? What is it? What are my refusal rights besides saying no?
The vaccination, that's outside of my purview and the nature of this specific webinar. But that is definitely something we should address in upcoming webinars that the firm does.
Do I have to close my business that feeds my family because I'm told to?
That facts will determine, the situation will be different. So determines on the facts. Is the city telling you? Why are they telling you to close your business? And what was around that? So that is a gray area type question.
What should I do if the hospital refuses to see me if it's not a SARS or a COVID-2 related problem?
That is one of those questions that is outside the purview of this webinar.
All right, and I think, let me see. Can the hospital refuse you from being with your loved ones in the hospital or even with your child?
Once again, I think your employer cannot rescind offers if the medical exam shows you have a weakened immune system. If an employer can require new employees to take a physical exam, but I'm not necessarily sure about the children, and yeah, that's not my scope of expertise.
All right, let's go to the chats and see if there's anything that hasn't been answered. Some of the attorneys have been answering some of the questions behind the screen. So
I think someone asked, what is the procedure if a person is facing an eviction? I think that's for Camrii.
all right.
So I know with a lot of the eviction things that I've done, eviction appeals, and that's when, you go to Justice of Peace Court, you've already, been evicted, you've had your notices placed on the door. There are time constraints to things which are covered, which time constraints to when you can set a hearing, when you can, when the writ of possession issues, and all that's covered in Chapter 24 of the Texas Property Code. But a lot of times you're going to end up going to the Justice of the Peace. If you don't show up, landlord wins, you have an eviction on your record, you're done. But you can also appeal it, which is a lot of times where I've come in and, take it to the district courts and the civil courts down at 201 Caroline. And, you can fight it, but the thing is, if it's an eviction, the only two things the judge would want to know is, was there rent due? Did you pay it? If you did not, that's kind of it. I don't know how many times I've sat in a courtroom and watched people try to explain their case. They didn't get the rats up. It's been hot in my house. And it's like, that's not why we're here. It's normally, I don't think eviction is normally a very quick process, especially if you get with with a judge, you can talk with them and ask them, hey, if I can pay this here, or if I can move out this, we, prevent this from, going on my record. So they're able to actually go and get another apartment. But a lot of these people, if their evictions proceeding on the first week of, in the next couple of weeks, they will actually have to of their apartments. So, or their rental homes, whatever the case may be. But it's not a difficult procedure at all. It's something that's done daily. A lot of times with just the initial evictions, apartment managers are going. You don't even need an attorney there. They're sending apartment managers and they're getting the evictions done. So it's not a long drawn out process or procedure, and a lot of people will be out of their their homes in this next month. I think you're paused, Chris. You're muted.
I'm trying to type and talk at the same time. We had a question in the chat room. What would you recommend your first steps are in estate planning? The person who was going to do estate planning was Salvador Benavides today. Salvador Benavides, and he's having some technical problems and wasn't able to join us today. So you can call our office at 713-227-1717. And we'll connect you up with Mr. Benavides, and he can answer all your questions. You can usually get a package deal from him, so that it takes care of your HIPAA releases, your power of attorneys, and the wills, and everything else all in one package. So I hope that answers your question. And we'll wait just a second to see if anybody else has any questions. Wanted to remind you again that we are on the internet, where the website is currently down. Because we're setting up a new website, but when it's back up, it'll be Liberating Law, www.liberatinglaw.com, or you can also send us an email at info@liberatinglaw.com, or you can call us on the phone at 713-227-1717. And we want to thank everybody that signed in today and listened to all the information. And we'll be back in a couple of weeks with another webinar, and we hope that everyone signs on for any additional new information that we have. Thank you so much, and thank you to all the attorneys that participated. And to everyone, we wish you a safe and happy day and a happy weekend.